record show that we're here on case number 2014 CR 532. This is the State of Ohio versus Donald Michael McCormack. State of Ohio is present, represented by Ashtabula County Prosecutor Nicholas Irochi and Chief Assistant County Prosecutor Cecilia Cooper. The defendant, Donald McCormack, is present, and he's represented by his attorneys, Richard Perez and John Fatica. So, it is the court's understanding that Mr. McCormack is going to plead guilty today to the following. Yes?
I believe it's no contest.
I'm sorry, no contest. Absolutely right. So he's going to plead no contest today to count one as amended, and it would be amended to attempted child endangering, and that would be a felony of the 4th degree. And then count 7, sexual imposition, a misdemeanor of the 3rd degree, and then count 9, sexual imposition, also a misdemeanor of the 3rd degree. So at this time, Mr. Irochi or Ms. Cooper, could you please go over the terms of the no contest plea?
Yes, Your Honor. As the court stated, the counts he is going to plead to, once that plea is accepted, the parties will then request that the court conduct a pre-sentence investigation. Once that investigation is completed, the parties will be back before the court requesting that the defendant be placed on community control for a period of 5 years, that he be noticed if he violates that community control for a period of 18 months, and he be required to serve 6 of those months immediately in the county jail. We will also be asking that certain conditions be placed on his community control that we discussed in chambers, but we'll go into more detail at sentencing. He will also, pursuant to this agreement, stipulate that he is a sexually oriented offender and that the people involved in the sexual impositions were minors, and as such will be required to register both under Senate Bill 5 and House Bill 180. One of the counts occurred while House Bill 180 was in effect. One took effect while Senate Bill 5 was in effect. The requirements of registration remain the same under both bills.
Okay.
He will still be required to register once a year for the next 10 years, providing his residential address, offense of conviction, and his employment address.
Okay, the plea agreement just mentions the Senate Bill 5.
Yes, ma'am, I wanted to correct that it is both Senate Bill 5 and House Bill 180.
House Bill 180. Any disagreement from the defense?
No, Your Honor.
So what the court will do is I will add in House Bill 180 here on the original plea agreement on page 3, and then I will initial it. Any objection by either side if I do that?
No, Your Honor.
No, Your Honor, thank you.
And finally, Your Honor, the parties have agreed that the state will not request restitution and that the defendant will not file an appeal.
All right, thank you, Ms. Cooper. Anything else?
No, Your Honor.
Okay. All right, Mr. Perez, Mr. Fatica, is that your understanding of the no contest plea agreement?
Your Honor, on behalf of Mr. McCormack, it is.
All right. And have you had enough time to review and explain in detail the meaning of the plea paperwork to your client?
Your Honor, I have. We had a copy of this before we entered the courtroom. I thoroughly discussed it with my client. He's read it, understands it, and signed it already, and we're prepared to enter a plea.
All right, very well. And you've had enough time to explain in detail the constitutional rights that your client will be given if he pleads no contest today?
I did, Your Honor.
All right. Have you shared any and all discovery information with your client?
We have, Your Honor.
All right. And are you satisfied that he understands the plea agreement as well as his constitutional rights?
I am.
All right. Are there any motions that have not been ruled on that either side needs to withdraw at this time?
Not on behalf of the state.
Okay.
Your Honor, I think you ruled on all the motions that we filed, so I don't think there is anything pending at this time.
I didn't think so, I just wanted to ask. All right, count one will be amended to an attempted child endangering. And Mr. McCormack, if your plea is accepted, counts 2, 3, 4, 5, 6, and 8 will be dismissed, okay? All right. So, Mr. McCormack, I'm going to ask you some questions at this time, okay?
Yes, Your Honor.
And you're welcome to stand up, but you're more than welcome to sit down too, because I've got about 40 plus questions for you, so if you want to be comfortable, that's fine. All right, but I appreciate your respect for the
Thank
court.
you, Your Honor.
All right. Can you read, write, and understand the English language?
Yes, Your Honor.
All right. Have you consumed any drugs, alcohol, or medications in the past 24 hours? All right. Are you a citizen of the United States of America?
Yes, Your Honor.
Okay. And have you had enough time to talk to your attorneys about this plea agreement?
Yes, Your Honor.
Do you have any complaints about your attorneys?
No, Your Honor.
All right, so you're satisfied with Mr. Perez and Mr. Fatiga?
Yes, Your Honor.
All right. Your attorneys have been retained by you, but if you ever cannot afford counsel, one would be appointed for you at state expense.
Thank you, Your Honor.
All right. And do you understand that there are special circumstances for a no contest plea, such as the possibility of civil liability where you may be sued or you are being sued over these incidents, and you may want to appeal any of the court's rulings?
Yes, Your Honor.
Okay. And have you been informed by your attorneys, and do you understand the nature of the charges to which you are pleading no contest to, which would be count 1 as amended, attempted endangering children, a felony of the 4th degree, count 7, sexual imposition, a misdemeanor of the 3rd degree, and count 9, sexual imposition, also a misdemeanor of the 3rd degree.
Yes, Your Honor.
All right. So the maximum penalties as provided by law are the following. For count 1 as amended, 4th degree felony, attempted endangering children, the court can impose a term of prison incarceration of at least 6 months, but not more than 18 months, or any number of months between 6 and 18 on this offense. You can be fined up to, but not more than, $5,000 on this offense. A non-mandatory penalty means that the law does not require that the court impose a particular penalty, but the court can impose the particular penalty at its discretion. So the term of incarceration on this offense is not mandatory, and the fine on this offense is not mandatory. So do you understand these penalties for this offense?
Yes, Your Honor.
All right. Now, for count 7, that's a misdemeanor of the 3rd degree, the charge is sexual imposition, the court can impose a term of local incarceration of up to, but not more than, 60 days in jail on this offense. You can be fined up to, but not more than, $500 on this offense. The term of local incarceration on this offense is not mandatory, and the fine on this offense is not mandatory. So do you understand these penalties for this offense?
Yes, Your Honor.
All right, for count 9, a misdemeanor of the 3rd degree as well, again a charge of sexual imposition, the court can impose a term of local incarceration of up to, but not more than, 60 days in jail on this offense. And you can be fined up to, but not more than, $500 on this offense. Again, the term of local incarceration as well as the fine on this offense is not mandatory. So do you understand the penalties for this offense?
Yes, Your Honor.
All right. All right, so the sentence for the felony offense, that's the amended count 1, that could be ordered to be served concurrently or consecutively if you had another felony offense. And I don't know whether you do or you don't. I'm just explaining this concept to you, okay, to see that you understand. So concurrent sentences mean that they run together or at the same time. And consecutive sentences mean that they run one after another or stacked on top of each other. So for example, let's say that you received 6 months on amended count 1 in this case, and then 6 months on another felony case you may or may not have. If these sentences run concurrently, you would receive 6 months, and if they run consecutively, you would receive 12 months. So do you understand that concept?
Yes, Your Honor. Thank you.
Okay. All right, do you understand that if I impose a prison term, that would be a term of certain, and that you'd have to serve the prison term imposed?
Yes, Your Honor.
Okay. And do you understand that if you're eligible under certain circumstances, you may be able to earn days of credit up to 8% of your prison time for your participation in certain programs at prison?
Yes, Your Honor.
Do you understand that the court is not bound to any agreed sentence between you and the state of Ohio?
Yes, Your Honor.
Do you understand that as an additional financial sanction, the court could order you to pay court costs?
Yes, Your Honor.
And do you understand that pleading no contest to this offense will have implications on your ability to own or use a firearm?
Yes, Your Honor.
Do you understand that by pleading no contest, you will be classified as a sexually oriented offender and will be required to register pursuant to the terms of Senate Bill 5 and House Bill 180 annually for the next 10 years?
Yes, Your Honor.
All right. Do you understand that if you are in prison, that after your release, you may be subject to post-release controls, rules and conditions you would have to abide by under the supervision and discretion of the parole board?
Yes, Your Honor.
Do you understand that if you violate terms of your post-release control, the rules could become more strict for you, and you could receive an additional prison term of up to 9 months? However, the total of all such prison terms could not exceed 50% of your original prison sentence.
Yes, Your Honor.
So, you're eligible for community control, and you could be subject to community control sanctions for up to 5 years, where you have conditions to follow, including up to 6 months of local incarceration. And if you violate any of those conditions, you could be given a longer period under court control, greater restrictions, or a prison term at the maximum. Do you understand that?
Yes, Your Honor.
Okay. All right, do you understand the effect of your no contest plea and its consequences?
Yes, Your Honor.
And do you accept those consequences today?
Yes, Your Honor.
Do you understand that under a no contest plea, you do not admit that you are guilty of any crime, however you admit to the truth of the facts?
Yes, Your Honor.
Do you understand that under a no contest plea, you're making the court the trier of fact, and based upon the state of Ohio's explanation of the circumstances and your admission of the truth of the facts in the indictment, the court will make a finding if you're guilty beyond a reasonable doubt on these counts?
Yes, Your Honor.
Okay. Do you understand upon accepting your no contest plea, the court may immediately proceed with judgment and sentence?
Yes, Your Honor.
Do you understand that you have a right to a trial in this matter, either to the court or to a jury?
Yes, Your Honor.
And are you waiving that right today?
Yes, Your Honor.
So I have here before me, it's a one-page, it's a waiver of trial by jury, and it's a one-page document, and it appears to have your signature on it. It has your attorney's signature as well on it. Did you sign this document?
Yes, Your Honor.
All right, and did you sign it voluntarily?
Yes, Your Honor.
All right. Do you understand that you have the right to confront and cross-examine witnesses against you?
Yes, Your Honor.
All right. And are you waiving that right?
Yes, Your Honor.
Do you understand that you have the right to subpoena witnesses to come in and testify on your behalf?
Yes, Your Honor.
And are you waiving that right?
Yes, Your Honor.
Do you understand that it's the obligation of the prosecutor's office to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
And are you waiving that right?
Yes, Your Honor.
Do you understand that you're not required to testify against yourself?
Yes, Your Honor.
And are you waiving that right?
Yes, Your Honor.
Do you understand by entering a no contest plea, you waive your right to appeal any issue that may have been brought up at a trial?
Yes, Your Honor.
And are you waiving that right?
Yes, Your Honor.
Do you understand that any appeal must be filed within 30 days after you are sentenced?
Yes, Your Honor.
Have you been fully advised by your attorneys about the plea negotiations in this case?
Yes, Your Honor.
And do you accept those negotiations as your own?
Yes, Your Honor.
Have you been promised, coerced, or threatened in any way into entering this plea?
No, Your Honor.
And are are you doing this of your own free will?
Yes, Your Honor.
All right. All right, I have here before me a written plea of no contest and plea agreement. It's a 4-page document, and it's a waiver of rights document. It was prepared by the state of Ohio. And I have here on the 3rd page, it appears to have your signature on it. Did you sign this written plea of no contest and plea agreement?
Yes, Your Honor.
All right. And did you sign this voluntarily?
Yes, Your Honor.
And did you review this document thoroughly with your attorneys?
Yes, Your Honor.
Okay. Do you have any questions at all regarding anything contained within this written plea of no contest and plea agreement?
No, Your Honor.
All right. So, Mr. McCormack, I've briefly gone over your rights with you. I know that your attorneys have gone over your rights with you in detail, and you've gone over them. So do you have any questions regarding your constitutional rights?
No, thank you, Your Honor.
All right. And do you waive those rights at this time?
Yes, Your Honor.
All right. Mr. McCormack, do you admit the truth of the factual allegations in the indictment for amended count 1, attempted endangering children, a felony of the 4th degree?
Yes, Your Honor.
Judge, we're just putting no contest, so we're really not admitting to the truth of those statements.
Well-
We're not contesting them, but I don't want an admission on record to content, since we're putting no contest.
The factual allegations of the indictment, and then I will listen to the circumstances provided by the state.
I think we will agree that the factual indications are in the indictment, but we're not admitting to those factual, we're pleading no contest, so
Right.
I believe the government or the state now needs to put on some evidence to establish that, but we're not admitting to anything in the indictment. We're just pleading no contest, which means we're not objecting to it.
You're not objecting to what's contained in the indictment regarding the no contest plea?
Well, we're pleading no contest, and I think at this point it's up to the state to establish a factual basis where you make a determination for a no contest plea, but I don't believe it's required that we admit to anything. We're not admitting to anything, that's why we're pleading no contest.
I understand that, but I've got to take the indictment, I've got to have that to review and then take a look at the facts of the circumstances that the state's going to provide me, and then I basically, make a finding.
Right, but I don't know that we're required to admit to the allegations. We're not denying those allegations are in the indictment.
Okay,
We're
okay.
just not admitting to them.
All right, okay,
Does that comport with your understanding, Nick?
Yes.
So,
okay.
I just
So,
want it for the record that we're not admitting
admitting
to
to,
anything.
okay, all right, very well. So your client, okay, so you're pleading no contest, but you're not, what's said in the indictment is what's in the indictment.
Well, a no contest plea is not an admission of
No, I understand.
anything. So, yeah, so we're, indictment has been filed, it's part of the record. We're pleading no contest. I assume the state will provide some evidence to allow you to make a decision. I mean, for purposes of the record, we would waive the reading of any evidence.
Okay,
If that's required, but I think in a felony, you have to make certain other determinations.
and I will.
Yeah.
All right, okay, so any objection to that?
No, Your Honor.
Okay. All right, then the state of Ohio, can you please give an explanation of the circumstances to the court for these 3 offenses? And if you could go about them in order.
Yes, Your Honor.
Okay.
As to count 1, the state would intend to show that on or between the 1st of January 1999 and December, sexual conduct and sexual contact over the course of the years, which included touching her breasts, touching her thighs, touching her vagina, repeatedly over that time without the victim's consent. that contact and that violation of trust has caused the victim severe and ongoing psychological pain for which she is still in counseling. So that would be the physical harm. It would be the severe psychological harm inflicted in that violation of trust, through that violation of trust and that violation of protection. As to count 7, the state would show that on or between September 1st, 1997 and March 31st, 1998, again, because he was a basketball coach in Jefferson, the defendant had contact with a young lady whose initials are KK, who was at the time 15. One day during that relationship, this defendant grabbed that victim in a hug that was sexual in nature, touched her breast, and began kissing her on the neck in a fashion that she found offensive, and she pushed him away. As to count 9, the state would show on or between June 1st, 2006 and July or August 16th, 2006. This defendant, again as a coach in Jefferson, came in contact with a victim by the initials of EZ. The victim was at the time 14. They were coming home from a basketball game. She was riding in the front seat of the defendant's car. The defendant began touching her leg, moved his hand up her leg, and eventually touched her vagina. Over her clothes. All of this contact took place over her clothes. The victim pushed his hand away so forcefully that the car swerved, according to her, thus showing that she found the conduct offensive.
Thank you, Ms. Cooper. Anything from the defense?
No, Your Honor, would be no contest, so we're not responding
I
to that.
understand. I understand. All right, so upon the consideration of the explanation of the circumstances that was provided by Ms. Cooper, the court finds that under count 1, as amended, which would be the attempted endangering children,
Your Honor, the state would also show that all of these offenses occurred within Ashtabula County.
So upon consideration of the explanation of the circumstances, the court finds that under count 1, which was amended to the attempted endangering children, that would be a felony of the 4th degree, that would constitute the offense named there in count 1. And also, upon consideration of the explanation of the circumstances, the court finds that under count 7, which is sexual imposition, a misdemeanor of the 3rd degree, that would constitute the offense as named. And then also under count 9, which would also be sexual imposition, a misdemeanor of the 3rd degree, that constitutes the offense as named. All right, so under the no contest plea, the court finds that Mr. McCormack is guilty based upon his plea of no contest. I understand that. Beyond a reasonable doubt, that's the court's finding. And that's of count 1 is amended, count 7 and count 9. And that's a felony of the 4th degree and 2 misdemeanors of the 3rd degree. Anything, did you want me to say something, Mr. Perez? Or?
No, I did not, Your Honor.
Okay, all right. The court finds that Mr. McCormack appeared here in open court today. He was advised of his constitutional rights as well as the written plea agreement. He's gone over that with his counsel for the written plea of no contest. Mr. McCormack understood and waived those rights before entering this plea. He understands the nature of the charges, the effect of a plea of no contest, as well as the maximum penalties in this case. I'm convinced that Mr. McCormack is entering into this no contest plea knowingly, intelligently, and voluntarily. And based upon the no contest plea to these three charges, amended count 1, and then count 7 and count 9, the court finds that the defendant has pled no contest to those offenses, and the court accepts that plea. All right, at this time, an order of pre-sentence investigation report be completed. Sentencing will be set for another time, and bond will be continued. Anything else?
Your Honor, did the court find him guilty? I might have overlooked that, I'm sorry.
The court, yeah, the court certainly will, obviously, the court has found the defendant guilty based upon his no contest plea. All right, yes. The court certainly finds Mr. McCormack guilty of amended count 1, felony of the 4th degree, and then the 2 misdemeanors, count 7 and count 9, the misdemeanors of the 3rd degree.
Thank you.
All right, anything else?
No, Your Honor.
No, Your Honor, thank you.
Okay.